Good afternoon, everybody. My name is Peter Shane. I've been asked to ask you on behalf of people taping this to turn off your cell phones. I've been asked to assure you that there will be 15 minutes toward the end of this program for what the program calls networking. I think that's an Anglo word for schmoozing with the panel. But I've been also told that we shouldn't schmooze longer than that 15 minutes without going upstairs because they need to use the room for something else. And that is as far as I go with the unilateral display of executive power. So I'm delighted to be moderating this afternoon's panel on the Unitary Presidency and the Obama administration. We're going to talk about two issues, two sides of the same coin. To what degree is the new president overturned the Unitarian practices of the Bush administration, and to what degree has he embraced, or should we want him to embrace those practices even in service of new policies? As it happens, the University of Chicago Press last month published a book of mine on the presidency called Madison's Nightmare: How Executive Power Threatens American Democracy. And you might guess from that title that I don't think things have been going very well with the executive branch. And you might guess that the Bush-Cheney administration gave me a lot of examples to dramatize what I think has gone wrong. I've written, however, what I hope is more than just a screed on the Bush-Cheney years. The book is really a set of arguments about what I call aggressive presidentialism. I portray presidentialism as a bad thing. I urge progressives to oppose it, even in a progressive administration. And I'm hoping that the book's central arguments will serve at least as a provocative foil for the panel, although I am acutely aware that I'm arguing against presidentialism at a moment when the country has chosen as its president the one president during my lifetime so far about whom I and perhaps many people in this room are most thoroughly enthusiastic. So this is a demonstration of my conviction, I guess. Madison's Nightmare weaves together three kinds of argument that I want to describe briefly: historical, legal, and political. The historical argument is that 1981 to 2009 represents a distinctive period in the history of the presidency. In essence, a bipartisan World War II trend toward enhanced executive power coincided with a right-wing campaign to steer the national government towards a radically conservative policy agenda. In order to further their policy ambitions, President Reagan and both Presidents Bush developed more aggressive theories of presidential authority than had ever previously been propounded. The Clinton administration disavowed much of their theorizing, but that administration made its own adventurous arguments, for example, for legal authority to bomb Serbia in 1999. President Clinton made claims for the presidential control of regulatory policymaking that in some respects went beyond even his predecessors. The Clinton administration, in other words, may have slowed the acceleration of presidentialism, but they didn't turn back the trend. That's the historical argument. The legal argument is that the Constitution doesn't support aggressive presidentialism. Presidentialists see the Constitution as creating a largely autonomous executive branch. In their view, the president enjoys a robust range of inherent authorities, both foreign and domestic, which are beyond the power of Congress to regulate or beyond the authority of courts to review. The presidentialists' arguments on both these fronts are, in my view, without substantial constitutional foundation. The political argument, however, is probably the most important. I argue that presidentialism promotes bad governance. As an operating ethos of government, presidentialism demeans the role of courts and Congress. It fosters ideological, inappropriate, and sometimes downright illegal decision-making. I argue that presidentialism is antagonistic to the rule of law and especially threatens to undermine the role of government lawyers in helping to take care that the laws be faithfully executed. And it does so in large part by eroding informal norms of accountability both within and between branches that actually provide the lifeblood of the rule of law in action. One particular view I hope the book challenges is the view that a president's unitary control of domestic policymaking promotes democratic accountability. Elena Kagan, whom I think truly wonderful in virtually every other aspect, has perhaps argued this view most famously among legal academics. My own view is that too tight a centralization of regulatory policymaking actually subverts political accountability. It undermines democratic responsiveness. It potentially weakens both the rule of law and the operating effectiveness of administrative agencies. I don't know if any of my colleagues on this stage share all of these views or any of them. I'm quite sure not all of them do. But I'm delighted that so distinguished a group of speakers has agreed to share their thoughts on the unitary presidency and the Obama administration. I have not asked that anybody explicitly use my analysis to frame their own remarks by way of agreeing or disagreeing, but I hope my remarks have at least explained why I think the stakes here are so important, and I expect that the panel's prepared remarks will be followed by some lively discussion. Because your printed program has each of our biographies, I will introduce the panelists now as briefly as possible. Lisa Bressman, Cheryl Harris, Nelson Lund, and I all teach law full-time at Vanderbilt, UCLA, George Mason, and Ohio State, respectively. Lou Fisher is a sometime teacher of law whose main employment is as a senior specialist in separation of powers with the Congressional Research Service of the Library of Congress. I think he fills an entire shelf of that library with his own books. Walter Dellinger, of course, is both an eminent law professor based for most of his career at Duke, now head of appellate practice for O'Melveny and Myers, and this year a visiting professor at Harvard Law School. Lisa, Nelson, Walter, and I are all alumni of the Office of Legal Counsel, which Walter, of course, headed from 1993 to 96 before serving as acting Solicitor General of the United States. Lisa will be our next speaker, followed by Cheryl, Lou, Nelson, and Walter in that order. We have each pledged on our sacred honor to expostulate for no more than 6 minutes, leaving ample time for conversation afterwards. We have a volunteer in front to hold up threatening signs. And having tried to keep up my end of the 6-minute bargain, I happily introduce Lisa Bressman.
Thank you, Peter. It is such an honor to participate on this panel, and I have agreed to start it off by addressing the question of what a progressive vision of presidential power might look like with respect to regulatory oversight. I want to offer some thoughts about progressive regulatory oversight and show you how it is beginning to play out in the Obama administration. Progressive regulatory oversight, in my view, should reflect a departure from presidential domination of regulatory policy. These are loaded words, so let me back up and explain. At least since the Reagan administration, the president has played a systemic and prominent role in controlling agency decisions, and this role has only increased through subsequent administrations, reaching what I would consider a tipping point in the last administration. Presidential control has taken two principal forms. The first is formal White House review of all significant proposed regulations through the Office of Information and Regulatory Affairs, or OIRA, within the Office of Management and Budget. And these are the largest regulations, 100 million or more, and they are subject to rigorous review, especially for compliance with cost-benefit analysis. The second main form of presidential control is presidential direction of individual agency policy decisions. And President Clinton was actually the one who pushed this role to the forefront. He stepped up the practice of issuing memoranda to agency heads, instructing them to use their existing regulatory authority to take a particular action. For example, instructing the FDA to regulate cigarettes and other tobacco products. The FDA had declined to exercise jurisdiction over such products until then, but with express presidential prompting, the agency went ahead. That's just one example. Now, a progressive vision of regulatory oversight would not require that either of these practices, either OIRA review or presidential direction of agency policy, dry up. It would not require that they dry up. For one thing, that would fly in the face of reality. Modern presidents will continue to seek involvement in regulatory policy, likely through these means and others. Furthermore, in my view, presidential control has the potential to make agency policy more rational and accountable. The problem is that presidential control has not always lived up to its potential. More balance and transparency are essential. So, the president should not use the tools of regulatory control to impose narrow or short-term preferences at the expense of other important public values. Just about every president to use these tools, including President Clinton, has made this mistake and has gotten into trouble. So you probably know that the Supreme Court struck down that tobacco regulation I just mentioned. The court said effectively that the Clinton administration was not entitled to move out in front of Congress on that issue. In this and other cases, the court can be seen to say that presidential leadership is not an unmitigated good. It cannot come at the expense of other important values, whether collaboration with Congress, respect for the states, consideration of statutory objectives and the rule of law, or principles of sound science. President Obama has positioned his administration to heed this warning. Where is the evidence? Well, it's still early, but let me attempt to sketch out what I'm seeing. President Obama has shown an interest in collaboration with Congress on regulatory policy. In addition, he has selected people to run his legal offices who have publicly rejected the notion that the president is all-powerful. Many in this administration have respect for the limits of presidential power, which is not to say that they do not support strong presidential leadership. They simply recognize that there is a stopping point. What about the presence of the czars, 21 and counting? Czars are policy advisors in particular regulatory areas like climate change and executive compensation, just to mention a couple. As you know, they are appointed by the president but not subject to Senate confirmation. Now, just the name czar seems less than progressive. Critics have complained more specifically that the use of czars represents an end run around Senate confirmation. They have also noted that the use of czars undermines accountability by transferring significant authority to persons other than the president. One critic notes that the use of czars undermines effective management, asking whether we need a czar to control the population that has emerged. I want to raise just a few counterpoints. First, note that the president has always had policy advisors. Indeed, he must as a practical matter. No CEO would run a major corporation without policy advisors. We would consider that bad management because no CEO has the information or expertise across all issues, let alone the time to address them. It's no different for the president. Second, policy advisors often have been non-Senate confirmed. The argument that the use of czars represents an end run around Senate confirmation assumes that Senate-confirmed officials would be making the decisions otherwise. That is frequently not the case. If the relevant individuals under the old model are not Senate-confirmed, then are we worse off under the new system? In fact, we may be better off. This ties to a third point. The use of czars, think about this for a minute, is transparent. We know who they are, and we know what they do. And even if we cannot hold them directly accountable, at least we know where the buck stops. Often agency officials do not even know who among the dozens of White House officials involved on an issue has the president's ear or reflects the president's view. It may be just a bit clearer now. I do not mean to deny or downplay the dangers of this practice. My point is simple. It's an experiment worth watching. Now, finally, I want to touch on OIRA. The administration has already taken progressive steps. First, the choice of a leader for OIRA, and second, the repeal of an intrusive George W. Bush executive order. Many have praised the selection of Cass Sunstein to run OIRA. Dean Ricky Revesz has described Sunstein as someone who will seek balanced regulations that do not break the bank. He will be sensitive to the nuances of cost-benefit analysis. He will be sensitive to the effect of regulations on real people. Now the executive order. Shortly after assuming office, President Obama revoked President Bush's regulatory review executive order. That order was different from its predecessors because it established presidentially appointed regulatory review officers at federal agencies and gave OIRA new authority to review agency guidance documents. Think about regulatory review officers as White House-installed watchdogs. They can inject presidential influence earlier in the process, even before an agency prepares a proposal, and kill actions with little transparency. And they are not Senate confirmed. Agency guidance documents, roughly speaking, are meant to assist parties in applying regulations. By definition, they do not have legal effect and are not the product of a public process as regulations are. For OIRA to review them suggests another level of intrusiveness. Now, we can debate the propriety of these innovations, but read from the agency side, they represent less transparency and more White House micromanagement. They are now gone. There are other issues we could talk about, the treatment of science, the politicization of staff, but I must stop now and sum up. Progressive regulatory oversight should deliver accountability, efficacy, leadership without sacrificing other important values. We need balance, we need transparency. Thus far, the Obama administration has made important steps in this positive direction. Thank you.
Thank you. Professor Harris.
Thank you, and thanks to Peter and to the American Constitution Society for convening this event and for allowing me to make a contribution to this discussion. I want to begin by acknowledging the importance of thinking hard about what the past several decades have taught about the use and abuse of presidential power. Peter's diagnosis is that it's not simply an ideological predisposition to claim excessive executive authority, but rather a structural drift that represents a departure from fundamental constitutional principles of checks and balances. This, he suggests, is Madison's nightmare, leading to a lack of accountability and erosion of democratic processes. I don't fundamentally disagree that the problem we have witnessed is deeper than simply the desire of prior administrations to operate without interference. But I do contend that that's not the only aspect of Madison's nightmare that's relevant here. Madison's nightmare was also that a government of have-nots would seize power and exercise control over the haves in a way that would threaten property. And of course, in the context of that historical moment, property legally included enslaved Africans. This fact was far from incidental to the constitutional order or the architecture that the founders crafted. Indeed, as Thurgood Marshall reminded years ago in Reflections on a Bicentennial, there were inherent flaws in the constitutional order deriving from the constitutional compromise which entrenched a system of racial subordination even as it laid a groundwork of democratic republicanism. The specter of populist reordering of power and resources worried Madison and his collaborators even more so than the contradictions of human property. And this led them to create a divided government to thwart the possibility of radical change, in part. The stability that Madison sought came with a high price, entrenching a system of racial and economic inequality. The structure that was created to check excessive governmental power in general and to curb executive unilateralism in particular was designed to do what it in fact did, make correcting inequality extremely hard. So here we have the double-edged sword, a structure created to deliberately make major change difficult. And the problem is that sometimes change is dangerous and violates democratic principles, and at other times change is essential to preserving them. So how does this relate to the problem of the claims of the unitary presidential authority? Well, it suggests to me that the diagnosis needs to take account of context. And that is, while aggressive claims of executive supremacy produce predictable areas of abuse of civil liberties and human rights, particularly under the claim of national security and foreign policy, with respect to domestic policy, and particularly in the arena of what we have come to traditionally call civil rights, some form of strong presidential power is essential. I am not arguing against the role for Congress, nor would I ever suggest that the courts are not important. I am saying, however, that in the absence of a robust exercise of presidential effort and authority to correct the distortions of civil rights law and policies imposed by past administrations, what results is a kind of perceived drift, one that allows opponents to continue to define the terrain. And since I'm calling for a critique in context, let me take some of my own medicine and place my own comments in context. Given the major role played by the Department of Justice in dismantling civil rights protections over the past several administrations, in one single act, the appointment of Eric Holder as Attorney General, the current administration has spoken volumes about a new direction. Substantial increases in funding for DOJ, more modest increases for agencies like the EEOC, as well as the embrace of the Ledbetter Act are also signals that this administration is different in important ways from what preceded it. At the same time, the lack of a more aggressive presidential voice and exercise of presidential power leaves a lacuna on critical questions of equality. It allows regressive forces that have declared any governmental intervention to alleviate racial disadvantage as race discrimination to continue to define the agenda. The opportunity to reframe the conversation about race, gender, and sexual orientation and the meaning of equality, a conversation that was poignantly begun before the election in Philadelphia and in other speeches, is at risk of being lost. This has meaning not only for particular communities or constituencies, but also potentially has significant political consequences more broadly. Two immediate examples come to mind. With respect to LGBT rights, there is an emerging critique that the administration has backtracked, or worse, with reference to prior commitments. The defense that more substantive change has to come from Congress has thus far not been persuasive to the critics, even though many will acknowledge that certain changes will require legislative action. The problem is that Congress may in some respects be lagging behind a change in the electorate that views some of the key issues around employment rights, familial rights, and other things with greater tolerance than in prior years. Race and gender equality issues are also an arena where aggressive presidential intervention has historically been crucial to meaningful change. If we think about the birth of the modern Civil Rights Act, It came out of a complex interaction between the demands of a vibrant social movement, national crisis, and a presidential push. The precursors to much of what we now recognize as key components of the framework of anti-discrimination law began as initiatives in the executive branch. That some began as weak gestures towards powerful political demands does not negate the observation that presidential power in this domain has been a necessary, if not sufficient, condition for change. Johnson's executive order on affirmative action, followed later by Nixon and subsequent presidents, offers one example of how critical the role of the executive can be. Indeed, the very origin of the terms equal opportunity, employment, and affirmative action come out of presidential initiatives. So I guess I want to contend that in the absence of at least some modest form of what Peter might call presidentialism in the context of civil rights, contemporary debates around critical issues of race and equality risk remaining stalemated or worse, fully captured by colorblind rhetoric and claims of post-racialism. The conservative effort to redefine affirmative action as racial preference has not only produced a hostile constitutional climate for affirmative action, it has threatened to delegitimate all forms of race-conscious remediation. Indeed, school desegregation programs have now themselves been recast as race discrimination. See Seattle and Louisville. And what we witness in Ricci versus New Haven is the conflation of disparate impact doctrine, the idea that neutral rules and selection processes that entrench inequality have to be justified, the conflation of disparate impact doctrine with affirmative action, or what the media repeatedly calls reverse discrimination. The tactical decision by the Obama administration to call for, quote, vacature and remand in a carefully argued brief in favor of New Haven seemed to reflect the sense that a more robust defense would be fraught. Of course, with the nomination of Sotomayor to the Supreme Court, Ricci has become a weapon in the hands of her opponents, and a particularly volatile one in the absence of any contest over the framing of disparate impact as a racial preference. While the administration has largely deflected discussion of race and has adopted race neutrality as its official stance, that is, that reducing racial inequality is a necessary byproduct of overall uplift, the proverbial rising tide that will lift all boats, this leaves it somewhat disarmed when it comes to defending this nominee. There are then some political risks to a lack of presidentialism, and I would argue that we need it to press the reset button on how we think and talk about race and equality, as well as gender and sexual orientation.
Thank you. Lou?
Yes, my appreciation to the Society for holding a conference, particularly on structural matters. So many years have gone by where people forget the structure is the way we protect rights and liberties. That's coming back, I hope. I agree with Peter that Reagan and Clinton and Bush II puffed up presidential power. I would go back a little further to Truman, was the first president who went to war without ever coming to Congress for authority, Korea, and instead went to the Security Council of the United Nations for authority. I defy anyone here to justify that on constitutional grounds, and yet that precedent was then used by other presidents. Bush I, going to the UN Security Council for Iraq, 1990. Clinton going to the UN to invade. I always ask audiences, who is he going to invade? People forget Haiti. He went to the UN Security Council for that, and also to the UN Security Council for Bosnia. So the notion that the Constitution, which gave Congress the power to not only declare war but authorize war, would allow a president to go to an international body and totally run around Congress is just constitutionally absurd. But we still have that system, and Congress has never protected itself. I think there is a basis, a good basis, for the unitary executive. I think a lot of that orientation should go back before the Constitution to the Continental Congress, where you only had one branch of government, no separate executive, no separate judiciary. And members of Congress had to legislate, they had to administer, they had to adjudicate. And by 1780, they were starting to experiment with boards of 3 people, and they found that was not accountable. You couldn't figure out who was in charge. And by 1780, 1781, they were settled on single executives. So long before the Philadelphia Convention, single executives. So by the time you get the Constitution and you get the first government in 1789 and you look at the first three executive departments, Foreign Affairs and War and Treasury, they were all headed by single executives for accountability and responsibility. Very important. And also in 1789, the first agreement that the president should have the power, not expressed but implied, to remove executive heads of departments, again for accountability and responsibility, because it's the president's duty to see that the laws are faithfully executed, and if a head of a department interferes with that, then the president has a right to remove that individual. So that's one side of the picture. The other side of the picture, which is very important, a lot of restraints on the unitary executive model, was that also in 1789 in the Treasury Department there was an officer called the Comptroller, and in fact he existed also back in the Continental Congress period, and he was the one to make sure that funds are legally spent. And Madison, who had argued so strongly for removal power for the president of executive departments, argued that the president should not have removal power over the comptroller. The comptroller was there to see that the laws were faithfully executed. The president has that constitutional role, but if Congress, by a statute, places on an executive official certain legal duties, the president has no business interfering unless those duties are not faithfully carried out. The president cannot carry out the law. He's to see that the laws are faithfully carried out. So immediately in 1789, you have this notion of ministerial power, where Congress by statute places certain duties on certain executive officials, and if those executive officials carry them out, the president has to stay out of it. And many attorneys general were asked by presidents, can I intervene here? And the attorneys general would say, no, you cannot, unless that person is not faithfully carrying out the law. So that's the ministerial duty. You also have, at the same time, adjudicatory duties inside the executive branch, and that, again, the president had no business interfering at all. It doesn't matter whether it's an independent commission or not. If it's adjudicatory duty of some kind of a claim or some sort of a pension or something like that, the president has no business getting involved, and no White House aide has any business getting involved. Those are legal duties by statute given to executive officials. What can we say about the danger, a real one, of implied powers, removal power and the rest, heading toward inherent power? Implied powers have to be reasonably drawn from express powers. That's how you protect your Constitution. Inherent powers, none of us in this room or in the world have any idea where inherent powers come from. But you know that when presidents invoke them, they can claim that they are not subject to statutes or to treaties or to judicial rulings at all. It's inherent. It's in the nature of my office. And you have Truman with the steel seizure case claiming that and getting struck down by the court. And you have Nixon claiming he could impound funds, getting struck down by the courts and by Congress. You have Nixon claiming he could do warrantless domestic surveillance, getting struck down by the courts and by Congress. And you have George W. Bush claiming a raft of things, military commissions struck down in Hamdan, claiming that he could keep people in Guantanamo without access to federal courts, struck down in Rasul. You have that you could prevent detainees having access to district courts, struck down in Boumediene. So unfortunately, this whole period, one part of that check and balance system was not functioning. That's the branch I work for, Congress. They were basically asleep. So I think we have to watch. All three branches have a constitutional duty to make sure that their own powers are not invaded and to fight back. That's what Madison hoped, and that's what we have not had for some time. Thank you.
Thank you. Nelson.
I'm honored to be here. So far, at least, President Obama's approach to the law of presidential power has been very similar to that of the Bush administration. And to illustrate, I want to talk a little about substantive signing statements, which contain constitutional objections to provisions in a bill that the president has signed. As you all know, there was a huge flap about this during the Bush administration. The American Bar Association, for example, adopted a highly critical legal analysis signed by eminent authorities like Dean Harold Coe and Judge Patricia Wald. They argued that it is always illegal for a president to sign a bill and then refuse to comply with provisions that he thinks are unconstitutional. Fortunately, in my view, President Obama has rejected that position. He has already declared that he will not be bound by several statutory provisions that he signed into law. Now, interestingly, some of these are identical to provisions that Bush had objected to. These are things that come up repeatedly in appropriations bills. If you read Bush's objections and Obama's objections without knowing who wrote which one, I don't think you could tell the difference. Another useful example is Bush's notorious signing statement on the McCain Amendment, which prohibited interrogations involving cruel, inhuman, or degrading treatment or punishment. Contrary to what a lot of people think, Bush did not say that he would ignore the McCain Amendment. All he said was that he would construe the provision, and here I'm quoting, in a manner consistent with the constitutional authority of the President as Commander-in-Chief to assist in achieving the shared objective of the Congress and the President of protecting the American people from further terrorist attacks. Now, you can fault this statement for being vague, but its vagueness is exactly why I think it's a mistake to characterize it as a sweeping power grab or as a nullification of the McCain Amendment. And there are also some good reasons to be vague about these things, which I'll discuss in a moment. But first, I want to point out that President Obama has sometimes been equally vague. For example, when he signed the Omnibus Appropriations Bill in March, he said that several provisions, which he did not specify, would, and I'm quoting, unduly interfere with my constitutional authority in the area of foreign affairs by effectively directing the executive on how to proceed or not proceed in negotiations or discussions with international organizations and foreign governments. In order to see why presidents do this, you need to focus on an important distinction that often got lost in the overheated denunciations of Bush. There is a big difference between claiming constitutional authority and actually exercising it. Shortly after he issued his signing statement on the McCain Amendment, for example, Bush was asked about it at a news conference, and here's what he said. What we're always doing is making sure that we make it clear that the executive branch has got certain responsibilities. Conducting war is a responsibility in the executive branch, not the legislative branch. But make no mistake about it. The McCain Amendment is an amendment we strongly support and will make sure it's fully effective. This is not an isolated example. As Dawn Johnson showed in an interesting article, lawyers associated with the Republican Party have tended to take a somewhat broader view than their Democratic counterparts, at least within academia, of the president's authority to ignore statutes that they think infringe on their constitutional authority. I therefore won't be surprised if Obama's record on signing statements eventually ends up looking somewhat more restrained than Bush's, at least at a rhetorical level. When it comes to actual refusals to enforce or comply with statutes, however, Democratic and Republican presidents behave in exactly the same way. They almost never do it. And when they do, it's almost always on an issue that's politically insignificant. Lou Fisher has done a lot of excellent work explaining why this is no accident. Based on the research that's been done so far, I think it's pretty clear that Bush was just like other presidents. After the Democrats took control of the House in 2007, the GAO did a study about this. And GAO found 6 cases in which the administration appeared not to comply with a statutory provision to which Bush had objected in a signing statement. In some cases, I think the administration probably did comply. But even where there was noncompliance, or pretty clear noncompliance, it seemed to result from factors other than Bush's constitutional objections. I expect that pattern to continue. Recent presidents have wanted to articulate their views of their constitutional authority. But, and for good reason, presidents are very reluctant to test that authority in actual battles with the legislature. I'd like to close by recalling an instructive episode from the past. In 1793, President Washington issued a so-called neutrality proclamation which forbade American citizens to get involved in a war that was going on between France and England and some other countries. This led to a famous debate between Hamilton and Madison. Hamilton took a broad view of executive power, somewhat similar to that of Republicans like David Addington and John Yoo today. Madison wrote a furious rebuttal, taking the position often associated with Democrats and congressional lawyers today. As with recent debates, there was something of a partisan undertone because Hamilton was somewhat more sympathetic to England, while Madison was more sympathetic to France. But the point I want to focus on is something that Madison mentioned almost in passing. As he acknowledged, the proclamation actually issued by President Washington could easily be interpreted to be perfectly consistent with Madison's own view of executive power. So in immediate practical terms, the debate between Hamilton and Madison was inconsequential. I think the same is true about a lot of today's debates about implied executive authority. Thank you.
Walter.
On August 6, 1787, the convention returned to Philadelphia from its one long break of the summer and reviewed the work of the Committee on Detail. To read that draft of the Constitution less than 5 weeks before the convention would rise and send its work to the states is really an extraordinary moment, because by then it reads like the present Constitution, using all the familiar nomenclature. But when you look at it, you see that the Congress appoints the president, and the Congress may remove the president for maladministration or neglect of duty. The Senate appoints all judges. The Senate appoints all ambassadors. The Senate makes all treaties, and the Senate chooses the Treasurer of the United States. In an extraordinary double move, the convention finally found a way to choose the president independent of the Congress. And having created a president with an independent base, which they thought would reflect the will of the people through electors pledged to candidates, they then could treat the president as a separate branch and give to the president a role in the selection of judges, the making of treaties, the choosing of ambassadors. That shift came about because they saw that over the summer the nationalists had triumphed, and that this national government had been given the extraordinary authority that John Marshall was described as stretching from the Atlantic to the Pacific, from the St. Croix to the Gulf of Mexico. All of the foreign commerce and a not inconsiderable portion of the domestic commerce of the nation were entrusted to it. And that government was going to need presidential leadership. Now, I think we have been through a period of time in which the president has exercised what I believe to be a legitimate authority to act as his own constitutional decision maker, to make his own determination of the Constitution, and to act on that determination, that has seriously threatened the structure of our government, but not because of the assertion that a president has the authority to interpret the Constitution and to decline to enforce provisions of law that the president believes is unconstitutional, but because of what I think is the era of the constitutional interpretation upon which the president acted. So that the ABA, in an utter misdiagnosis of the problem, and saying we're not intending to be critical of the Bush administration, suggested that no president should sign a bill into law and announce that there was a provision with which the president would not comply. Every modern president has asserted that authority, and rightly so, in my view. Going back to 1860, in the case of Captain Meigs, where the Attorney General says the President need not comply with an act of Congress purporting to appoint an officer of the United States. But I think what has happened, though, is that while the President has that authority, the extraordinary claims of the substance of the authority during the administration of the most recent President Bush is the heart of the problem. I believe that the President has the authority not to comply with unconstitutional statutes. But these are cases where the President refuses to comply with statutes that are, in my view, indubitably constitutional. The Foreign Intelligence Surveillance Act defines how foreign intelligence should be conducted, and without any showing that it impinged upon any essential authority, the President was disregarded and done so in secret. The torture laws enacted under Congress's Article I authority were disregarded under the shabbiest and most tissue-like justifications. That, to me, is the problem. But it's no more the right solution to say that we must now assume that presidents have no authority to refuse to comply with statutes than it would be to respond to the, say, Seattle and Louisville decisions or the perhaps forthcoming invalidation of the Voting Rights Act by saying that the problem is in Marbury versus Madison in 1803 and in judicial review. I think the large issue on which, there are two large issues on which the previous administration took us way off course. One was in the conflation of two very different meanings of inherent authority. One is inherent authority to act when Congress has not spoken to the issue. I believe that presidents do have significant independent authority, particularly in the areas of national security and defense. That is to say, it would be rare that a presidential action in those areas would be invalid merely because it was ultra vires. But once Congress has exercised its powers under Article I, things shift completely. And yet what we saw in defenders of the previous administration was, well, we said the presidents have inherent authority to wiretap, then Congress acts. Obviously, they can't invade an inherent authority. They're using it in a very different way of an immunity from acts of Congress. That immunity should come only in the rarest cases. And I think that in response to the torture memos and the FISA position, Dawn Johnson led a group of former OLC officials to set out standards by which a president should take account of the positions likely to be taken by the court. And more importantly, or of equal importance than the processes set out in the Johnson memorandum, were the notion that we should have something like an OLC reporting act, so that these are not done in secret. And with very limited exceptions, the president should inform Congress of when he is not complying with an act of Congress or construing a statute under constitutional doctrine so as not to comply. What is, I think, very fundamentally a threat to the way our country operates is for a president to take the authority, to decline to obey the law, to give himself a sweeping sense of what that authority entails, and then to do it in secret. Because then there is no check. And the OLC Reporting Act would make these matters visible in almost all instances. So I think at the end of the day that presidential leadership is strong. The president's decision to direct the FDA to undertake the regulation of tobacco was struck down, but 5-4 in what I think was an unpersuasive opinion. At the end of the day, when you look back on our history, what you see is that the national government has settled the Western lands, mobilized the extraordinary resources and the loss of hundreds of thousands of lives to put down the rebellion and end slavery, to take on the greatest economic depression the world has ever known, to reverse the era of Jim Crow, to win the Cold War, and to create a social safety net. That is no small list of achievements for any country, and I think that strong presidential leadership has been a part of that, and that we should therefore be careful that we don't unduly deter the exercise of presidential leadership. Thank you.
Well, if we only had some things to talk about. So I'm going to resist. It's hard to be on a panel as both participant and moderator, but I'm going to try to be moderator here and ask a question, because I do think, well, Walter, one way of hearing what you were saying is that the problem isn't the problem weren't the modes of presidential expression, but the theory underlying the powers that the president was claiming. And Cheryl was sort of inviting a kind of analysis that would differentiate when vigorous presidential leadership is needed in favor of kinds of change that might not otherwise occur and are urgently needed versus times when we would want to have the kind of more stable consensus-building gradualist approach. I guess what I'm wondering is whether there are ways of distinguishing between presidential vigor and what I'm calling presidentialism. That is, and and I'm wondering, and this is not a rhetorical question. I'm actually, so I'm inviting us to sort this out together. Cheryl again mentioned the disagreements that the administration is having with the LGBT community. And one of the ways in which an administration, of course, can express its view of things is in writing briefs. So, Walter, you've been acting Solicitor General. You've undoubtedly sort of thought about these issues. The administration was called upon to defend a law enacted by Congress, a law deeply offensive to many Americans and certainly many of the administration's strong supporters. The president, I don't know what his inclination would have been. He apparently did not say to the Justice Department, this is how you shall write the brief. The brief got written in the ordinary course of things. Should presidents exercise their discretionary authority in the name of leadership, or is it more important to preserve the norms of ordinary lawyering, allow those positions to percolate, in a way that is at arm's length removed from? Do you see what I'm getting at? I'm trying to sort of figure out how these informal norms of structural operation affect the kinds of presidential action we worry about and the kinds of presidential action we applaud.
I think that the president really is invested with the authority of the executive branch. And when you're putting aside noncompliance with acts of Congress, like torture and FISA, but you're talking about whether the president can control the executive branch, I feel that very strongly. Now, on the particular case, what should the Solicitor General or the Attorney General do with respect to a brief defending the Defense of Marriage Act when the president doesn't like the bill and the Department of Justice is defending it? First of all, the Solicitor General or the Department of Justice has to realize that they have only one client, and that client is the United States. It's not the president or the White House or anyone else. But they should also recognize, number two, that for a Solicitor General, his or her boss is the president in whom executive power is vested. Now, the president should also recognize at the third stage that his client is the United States, not himself. So that you have, I think, an obligation to defend an act of Congress, whether you like it or not, unless Congress has repealed it. You have an obligation to go into court and defend it. That said, the president, the Department of Justice is an advocate. The real independence has to be at the Office of Legal Counsel. You're placing constraints on the executive branch. In some sense, the Solicitor General is reflecting the views of the United States to the court, and I think the president gets to deflect those views. So I would have been very comfortable with a president saying, I don't like the tone of this brief, and I think it ought to be changed. I realize, like it or not, we have an obligation to defend an act of Congress. But there are several things that could have been argued quite differently in this brief. You could have said there's a strong case against this law. And here it is. But here's what Congress thought, and we present this to the court. I think it could have been quite different, and I would not object to presidents doing that. I think usually the president should listen to the Department of Justice because they are reflecting an ongoing tradition. But at the end of the day, it is not clear that there's not politics at the Department of Justice among career people, as well as politics. It's just a different kind. In some ways, the worst kind of politics is the politics that doesn't understand that it's the politics. So that usually the president should listen to what his legal officers have to say. But ultimately, the decision is his, and I would not back off of saying that I think a president, is entitled to weigh in on an issue like that.
Peter, I want to get to your distinction between presidential vigor and presidentialism that you're concerned about. And there is a legitimate way for presidents in time of emergency to exercise power and protect the Constitution. That's the model that Lincoln used. We've never had a controversy, a crisis as deep as the Civil War. Lincoln took all the actions we know of, which were not authorized and which were against the Constitution. He never claimed to act constitutionally. He said to Congress when it returned whether acting legally or not. He said he admitted that he exercised not only his Article II powers, but he exercised Article I powers. He admitted to Congress and the country he exercised power outside his domain, and came to Congress and said, out of necessity, I did these things, and I need you to pass legislation authorizing what I did retroactively. That's how you keep a Constitution together. So certainly Bush II could have done the same thing if he thought for some reason Pfizer was too restrictive on him or other things. He could have said temporarily, I'm acting against the law, but I'm coming to you to make the law whole. That's the model.
I guess,
No. I'm sorry.
I did just want to speak to the distinction that you drew. I take the point, Peter, of the question to be that perhaps one way of reading my argument would be to say that I'm simply asking for presidential vigor. And I suppose that would be fair, but I guess I would say, to my mind, one of the things that is important to think about in terms of the overall critique is to think about context, not only in terms of the domain in which power is being exercised, but something that Lou just sort of acknowledged, which is what is the moment. And in that regard, I guess my point was to say that I do think that there is a role for the executive in a particular context to push the envelope. And that's what I'm basically trying to articulate, that it need not be a situation where the answer to every sort of initiative is we have to wait for Congress. I don't think that that's a model that necessarily leads to better democratic principles or the observation of greater democratic accountability, in part because in certain respects Congress may itself be stalemated over critical questions. Now, I realize that leads one down the path of sort of saying is this sort of content-based. If I like what they're doing, then it's okay, and if I don't like what they're doing, it's not okay, and I want to be sensitive to that. But I am saying that I do think that there is a role for thinking about context in which particular assertions of executive authority are being made. And I'm much more, I guess I would say, cautious about those claims in the context of national security and foreign policy than with respect to certain aspects of domestic policy. I guess I would draw that distinction.
Nelson, I saw your wave.
Yeah, I want to go back to something that Walter said. I agree with a lot of what he said and what he's written on this subject, but there's one thing that I disagree with in what he said, and I think it kind of points toward a broader issue. If I understood you correctly, you said that the client of people in the Department of Justice is the United States, not the President. I disagree with that. I think that the client of all lawyers in the executive branch is the President in his official capacity, but it is the President. And the reason I think that is that the Constitution gives the executive power to the President, and everything that the lawyers do in the Department of Justice is kind of has to be understood in light of that fact that the entire executive power, whatever it is, belongs to the President. And I think there are some practical problems when lawyers in the government start substituting their own idea of the public interest for the President's. They weren't elected. He was. And he's the one that has the authority. But it's also worth emphasizing, I think, that when the Constitution gave the executive power to the President, it didn't define it. And the process of trying to define the limits of that power hasn't been a purely legal matter. It's been a kind of combination of lawyers thinking about it and clients, like presidents, exercising what Madison expected them, the Federalists expected them to exercise, exerting their own interest in the interest of their office in a struggle of ambition against ambition, and to try to cut that off and let kind of disinterested lawyers who kind of think of themselves as courts, kind of like courts, but who are not courts, kind of substitute their judgment for that of the President, I think is a mistake.
I just want to clarify, this may be a very subtle distinction, Nelson, but I do agree that for any official in the Department of Justice, her boss is the president. So that if I meet with the president, and these are close to real examples, and say, I believe we have to defend a certain act of Congress, and the president says, I don't like it, my answer is, sir, your client, as well as mine, is the United States. This is the law of the United States. Now, at the end of the day, the president can say, all right, I realize my client's the United States, but I'm the senior lawyer representing that client, and you're overruled. But everybody's obligation is to advance the interests of the United States. Now, I do admit to being chastened in my view of presidential authority to decline to obey acts of Congress by the experience of the last 8 years. The dialogue I had with Judge Mikva when he was White House counsel, when I informed him that every president said you don't have to obey laws that are unconstitutional, his response is, well, that means the president can just disregard any law he wants to. I said, no, not at all. Only if his responsible lawyers tell him that it violates the Constitution, and if that violation is clear, it doesn't give him the authority just to disregard any provision he doesn't want. And so you're assuming there'll be integrity in that process. And I said, yes, I am. And I was able to point to instances under administrations, Republican and Democrat, Reagan, Bush, Carter, where against heavy pressure, OLC had stood up and said no to the president. So I had actually seen it done. I must admit that I now seem more forced to Judge Mikva's point than I did earlier.
Nelson, did you?
Maybe this shouldn't be pursued too far, and maybe there is just a semantic distinction. I don't think the president has clients. He certainly has responsibilities to the United States. I certainly agree with that. But I don't think he has clients. But just to give an example of why I think the distinction may be important, at one point prior to our entry into World War II, Congress passed a legislative veto. And the Attorney General thought it was perfectly constitutional, thought it probably was, and he told President Roosevelt that. And President Roosevelt said, fine, I'm going to write my own legal opinion overruling you on that, which he did. For political reasons, President Roosevelt kept that a secret. But it turned out eventually that the Supreme Court agreed with President Roosevelt many, many years later, rather than with Attorney General Robert Jackson. And I think that I personally am inclined to agree with Attorney General Jackson about that. But that's the way things worked out over time. And I think it really is important that these decisions about the scope of executive power not be dictated to the president by people who haven't been elected by anybody.
Luke?
Yeah, there's another nice example, too, of Franklin Roosevelt and something that was not secret, another signing statement. And that was the Bill of Attainder Act that Congress passed in 1943, denying funds to 3 people, not for their actions, but for their opinions. And very nicely, it was a signing statement by Roosevelt. He needed the money. He couldn't veto the bill. It was an emergency World War II funding bill. But in his signing statement, he said he regards this as a Bill of Attainder and flagged it publicly. And it was litigated, and the Supreme Court, in the Leavitt case, several years later, in 1946, struck it down. So to me, that was a very healthy use of a signing statement by a president in public.
Well, again, I'm going to refrain from explaining my view of signing statements unless somebody asks me.
I do want to know your views. I want you to. You've thought a lot about this. I want you to weigh in.
Well, I think, I agree actually that with you and with Nelson that the ABA report simply went too far, and that the idea of the occasional signing statement that registered a customary and well-founded separation of powers view of the executive branch is untroubling to the interaction of the branches. The problem is, in his first 6 years, I actually have a research assistant this summer counting up the last 2 years of the Bush administration, but in the first 6 years, he objected to 1,400 provisions of about 1,400 provisions of, I forget how many statutes there were. I'm sorry, he made 1,400 objections to about 700 provisions in about 125 statutes. And it's fine to say it's okay for the president to assert the commander-in-chief power, but my favorite one was when he said the commander-in-chief power precluded Congress from specifying how many members of the military in active service could work for the Pentagon's Office of Legislative Liaison. Now, I understand that presidents may think they're at war with Congress, but I mean that's absolutely ludicrous. And clearly, there was an effort to object as many times as possible. Now, Nelson makes the point, which I take to be right, that even President Bush 43 probably acted upon these things very rarely. But that only raises the question, what's the point of saying 1,400 separate times what you're not going to follow through on? And the point is to communicate to the executive branch that if we don't want to listen to what these other branches are telling us to do, we don't have to do it. That's what I mean by presidentialism as an ethos of government. And what's hard about setting the appropriate limits is that the limits really are matters, I think, more of informal norms than precise rules. That's why I think the statement that Dawn and other OLC lawyers put together about, the recommended practices of OLC, which actually I take it she regarded as an actual description of the way OLC had operated prior to 2000, was such an important document because it didn't try to state rules as much as norms. I do want to keep, about 20 minutes for the audience, but I just want to ask everybody to weigh in on something quickly, just so we know where everybody stands. So just a quick hypothetical. What do you think? Congress issues a law directing the Secretary of the Treasury to transmit to Congress on an annual basis and without prior White House review, an accounting of all recovery spending. Constitutional or unconstitutional?
I'm not going first. I have to go first on the panel here. Well, I mean, it does give me an opportunity to make a distinction here without answering Peter's nice question, yes or no. I'll let Walter answer it first.
Law professors.
Law professors. I just wanted to offer a brief comment about the we have to wait for Congress point. I think it's hard to know when the administration has to wait for Congress. A lot of the examples I spend my time on in the regulatory state with respect to administrative agencies, are where Congress has given the agency / the executive branch room to move ahead. And a lot of the examples that have caused administrations trouble are where Congress or the states have begun to take some sort of a role or have been active in the area. At least that's what the Supreme Court says if you believe them. And so there's a kind of an active debate that has arisen, at least among law professors, if not judges, about when the administration has to wait for Congress. With respect to agencies, not all that much, not as much as you would think, because the whole concept of delegation, the delegation of authority to administrative agencies permits the agency to kind of push the law out and ahead. But there are instances, and I think that's what we're talking about here, instances in which words like accountability are thrown around, but actually when you look at the actual exercise of authority, you wonder whether there's true responsiveness or representation going on. And so I just want to make that point that a lot of this is context specific, and you have to really look to see what the nature of authority is. Now I'm going to let Walter answer the question, and then I'm going to say I agree with Walter.
It's unconstitutional. And it's unconstitutional because Congress has a great deal of authority to define what the executive branch may do and may not do. Torture or not torture. Eavesdrop by going through FISA or not. But to tell the president who gets to do a certain action, I think very fundamentally crosses a line and takes us down the road of depriving us of presidential vigor. Congress can place a duty of reporting upon the executive branch, but it can't tell the president, this person has to submit it directly to Congress, and you can't decide that someone else should review it before it goes. To me, that's an easy question.
Okay. Cheryl, do you want to weigh in on this?
I'm glad it's an easy question. I'm going to write it down for my next constitutional law exam. And I'm going to say that as I follow it, I think I agree with Walter. It seems to me that these distinctions in the context of separation of powers might sometimes seem rather fine, but the question of who versus what is one of those distinctions. So I'm going to go with that answer.
Yeah, Peter's question is unfair because it requires a long time to do it.
That's why it's a good exam question.
Yeah, and why students hate it, including this one. I think Congress can tell a president he has to send up certain recommendations, and maybe there's a commission around to set forth some sort of a compensation or pay. And then the president has a duty. He can either send up the commission recommendation or he can send up a substitute, but he has to do one or the other. So that's my weaseling in the middle there to make it more complicated.
I agree with Walter.
Right. So just want to turn to the audience and just acknowledge, of course, that this is all irrespective of the fact that the first Congress suspended having a committee on Ways and Means and had the Secretary of the Treasury functioning at least as much as an operative of Congress is of the executive branch. So much for originalism. But yes, so there are people with microphones who are going to help with this so that questions can be...
Let me start with Jack and I'll repeat the question.
Okay, well, we'll do it that way. But are there not?
I found myself in agreement with so much that I'm left with this objection to Professor Bressman's criticism of Clinton for getting ahead of Congress about tobacco. That was the issue in the Supreme Court, whether the FDA had got ahead of Congress. The Supreme Court 5-4 said it had got ahead of Congress. The Supreme Court was very wrong about that. The FDA had a terrific case that under existing law, that cigarettes were a drug delivery system. It was a monstrous overturning in the end. But to blame Clinton for getting that started, I think, is out of whack.
Do I get to respond?
Yes, sure.
So I was characterizing the court's 5-4 decision as opposed to offering my own view of whether the decision is right or wrong. I have written an article on it in which I connect that case up with a bunch of others from other administrations, not Democratic, in which I identified the court as articulating a kind of a principle as applied to the exercise of authority over administrative agencies. And that principle, to the extent it holds today, which I'm not clear that it does, says that when administrations direct agencies in certain ways that are suggestive of a lack of accountability, the Supreme Court will step up and say no. Now, just out of, in excess of candor, when I was at OLC, we were working on the tobacco policy, and I didn't see a whole lot wrong with it back then. And I clerked for Justice Breyer, who was the guy in the dissent. So I think you have to take what I'm saying in context. There's a line of cases out there from the Supreme Court describing a kind of a presidential practice with respect to agency decisions. And to the extent you can take away a principle from that, it says that when administrations act in certain ways with respect to agency decisions, they will find themselves in trouble. And I think that proves out through connect the dots of a bunch of cases.
That case is so much of an exemplar about the issue of presidential control of agencies. I argued that case in the Fourth Circuit. Two of the judges were chain smokers. One of the judges who was in his late 70s, I was told by the U.S. Marshal, had a mother who was a chain smoker. And they were buying none of this. But I kept talking about Chevron deference, which in the penultimate paragraph, Justice Stevens' opinion of Chevron says that you give deference when the statute isn't clear. You give deference to an agency because though the agency is not elected, it's responsible to a president who was elected, unlike judges. And so when someone with political accountability and elected accountability makes a decision about an ambiguous statute, unelected judges should yield to it. But they kept asking me over and over again, wasn't the president involved in making this decision? Didn't the president get him? I kept saying, yes, that's the point of Chevron. He announced it before he was running for re-election. He did it afterwards. That's why you should defer to it. I think the president was involved in it. Well, at the end of the day, my wife is a very good lawyer, said it was a 3.5-hour argument. My wife is a very good lawyer, said afterwards, two things emerged from that argument. One, none of the judges had ever heard of the Chevron doctrine. And number two, when you explained it to them, they did not like it.
So it's interesting, by the way, because Lisa in her presentation also mentioned kind of the routine regulatory oversight operation of the Office of Information and Regulatory Affairs. So the current system of oversight, I mean, it had some ancient seedlings in the Nixon administration, the Ford administration. Carter moved it a little forward, but it really flowered under President Reagan. And President Reagan was the first president to issue an executive order that said, thou shalt send your proposed regulations to OMB and thou shalt not publish them until OMB signs off. There is an OLC memorandum to David Stockman that explains why this is lawful. And one of the things that it says is, this is lawful because the president has taken great care to clarify that he is not displacing the decision-making authority of the agencies where Congress has vested it. And so I just put that out there. I want to ask questions on the right, too, although I hasten to add they don't have to be rightist questions. Yes, and toward the back. Is there... I see a hand up.
Hi, my name is Kai Scafari. I'm a rising 2L at Duke, actually. My question is about presidential signing statements. I know that in the early founding period, there were several instances where the president vetoed the whole bill because there was one provision that he felt was unconstitutional. Is the only objection to that in the modern day that it's just not practical? Or it seems to me that that's a very simplistic, perhaps impractical solution or that kind of sort to the issue that's at hand.
Interesting question, because in that early period, some presidents would veto a bill because it had funds in there that the president didn't like, and the members of Congress said, you don't have to veto the whole thing if you don't like it, just don't spend for that particular purpose. So in our history, there has been that kind of understanding, and then it got misused horribly in the Nixon years, where you would not only cut out programs in whole, you would cut them in half, you just obliterate them. I do want to say on the signing statements, there's another option here, and that's about 1/4 of the signing statements today have to do with legislative vetoes, and presidents say it's a violation of charter. The interesting thing is that I would think 100% of the times, even the president says the committee vetoes or subcommittee vetoes are unconstitutional under charter, they go ahead by the agencies and department without any interruption. So you have a total disruption between the executive branch, between the president saying one thing and the Justice Department one saying, and then the agencies just saying, look, we have to make agreements with committees and subcommittees. We need to get their approval before moving money around. So that's one thing that the public doesn't understand very well, and I'm not sure the academics understand it very well.
Well, can I just say, Nelson and I were on a panel on signing statements a couple of years ago, and Mike Rappaport at San Diego, I think, took the position, didn't he, that the president's obligation to take care that the laws be faithfully executed might well imply that if he thinks part of it's unconstitutional, he should veto the thing.
I spent a long time trying to figure out exactly what his argument was, and I think I failed because I wrote what I thought it was in the law review, and then he wrote something saying I misunderstood it, and I still don't understand it. So I have nothing to say about it.
Fair enough.
Look, certainly there's a case to be made that a president's obligation is to veto the whole bill. I don't agree with that. But assuming that you do, and the President ignores that, and he signs the bill as unconstitutional provision, it seems odd to say that that President is somehow stopped and has to comply with the provision, no matter how onerous it is or how adversely it affects the civil liberties of an individual, for example. But that if he stepped aside and is replaced by another, that President, of course, would be free and should disregard the unconstitutional provision because the subsequent President didn't sign it. That, to me, makes no sense. There's no estoppel doctrine. And whatever you think about whether the President should sign, it's a very tough case. I mean, the toughest case we had was when Congress passes a defense appropriations bill and then recesses for the long recess. And in that bill, the Omnibus Defense Appropriations Act is a provision that requires the testing of every member of the service for HIV and the mandatory discharge within 60 days of everybody who tests positive. Out of the military, no medical benefits, whatever. And the President is torn. What is he going to do? He doesn't like the provision. He wants us to say it's unconstitutional so that he can sign the bill and announce not to worry about this provision. We agonize over it because we thought the court would uphold it. It's over-inclusive, it's under-inclusive, but it's in the area of military affairs, and this court was likely to defer to the judgment of Congress. So we were torn because we thought the court would uphold it. In the end, we said you should sign it and the Secretary should implement it, but the Department should urge the court to strike it down on the grounds that the usual deference to Congress wasn't warranted because the President's senior military advisors believed the law to be not only not to advance a legitimate public objective, but to be actually a law which harmed our military preparedness by taking away key people and by, as General Shalikashvili put it so powerfully, by violating the principle we do not leave our wounded behind. He thought it was a horrible bill that undercut a principle of the military. And so we were going to argue against it and let Congress argue in defense of it while formally initiating it, but we would join with those who attacked it in filing the brief. Congress then repealed it. Faced with the task of defending it itself, it repealed it. I still think it's a tough question. I'm not sure we shouldn't have just said it's unconstitutional because the President thinks it doesn't advance a legitimate public interest, even though the court would uphold it. I think that's one of the options. The other option at the other end would be to defend it all the way. We did something in the middle. I'm still not sure it's right. I think it's the toughest case in this kind of case in this area.
Can I try to get in two more questions before schmooze time? Yes.
Hi. I wanted to follow up on something that Mr. Fisher said. I wanted to follow up on something that Mr. Fisher said, which this idea of going to war, committing troops to war, skirmishes, whatever you want to call them, without Congress declaring war. And you said that Congress has never stood up for itself. And I want to ask the panel why they think that is, all the times that that's happened since, I guess you were saying Harry Truman did it the first time. Why Congress doesn't guard that power more jealously.
Okay, quick response is that when Truman did that, first of all, I think it's clear in the UN Charter and the UN Participation Act of 1945 that if you're going to send troops in an agreement with the UN, you go to Congress first and get prior approval. And when Truman was in Potsdam, when the UN Charter was being debated, he told senators, make no mistake about it, I would never send troops into a UN operation without first getting the approval of Congress. So why is it in 1950 he goes to war on his own, he never comes to Congress? And I think it's because members of Congress had a choice between defending their institutional duties and the Constitution versus fighting communism. And I think that was the truth then. So we give up on the Constitution so often when we say, oh, we're fighting against communism, it's fighting against terrorism, we're fighting against something else. And you can do both. Congress could have told Truman and should have told Truman, you come up here, you didn't come up first, but you come up later like Lincoln did, you come up now and get authority. But members of Congress, unfortunately, more and more are less able and interested in protecting their own institution. There are very few I came to Congress in 1970 and worked with so many people who understood that, and there are very, very few today. That's the way it is.
I don't know whether he's going to do anything about it, but when Vice President Biden was in that other branch, he actually proposed in the mid-'90s, I thought, a quite good rewrite of the War Powers Act, which would have gone some distance in recalibrating the balance between the branches.
Unfortunately, that Biden bill would have made an exception that if the president goes to the UN Security Council, that's an acceptable exception. So it would have pushed Congress totally out of the picture.
Yeah. If there is a law, I would love to give the last opportunity to a law student. If there is a law student question, yes, I see a. Oh, wait for the microphone, please.
Oh dear.
I've been thinking about this question for a while. I don't really know exactly if it's going to come out right, but this is for.
Could you hold the mic closer to your mouth, please?
Okay. With respect to predator drone strikes, do you think they are subsumed in the president's commander-in-chief powers, or could the president do that, then get subsequent authorization from Congress, and if Congress doesn't authorize it, but they don't speak against it, how do we ensure that what the president is doing is legal?
I missed a word there.
I think we were talking about the use of predator drones. Is
Right.
that what you said? Okay.
Oh.
In other words, can the president assert an end run around congressional authorization saying that these are subsumed in the commander-in-chief powers because it's a tactical move? Granted, it's unlike extracting information from detainees or wiretaps, which the previous president asserted within his commander-in-chief powers. Could the president, I guess, use the same framework for commander drone strikes?
I see your head nodding affirmatively.
I don't know.
Lou, you wrote a book about war powers.
No, I hope we could be clear that the only branch authorized to take the country from a state of peace to a state of war is Congress, and that we haven't obeyed for a long time, since 1950. Your question about tactical moves on Predator and so forth, that's somewhere in the middle ground, and presidents do that. They've taken a lot of initiatives over the years, and it depends on how well it goes in Congress. In the end, Congress can always override a president's decision. You may be facing a veto then. But on the main thing of going to war, that was so clearly congressional judgment, framers' judgment, that that's only for the legislative branch, and we've lost that value.
One last word.
Sure. Walter?
Yeah, we through.
Yeah.
The single best thing a president can do to ensure that his administration complies with the law in good faith is to make sure he has a very strong person of undoubted integrity, Senate confirmed, running the Office of Legal Counsel, and that person is Dawn Johnson.
Well, I mentioned. I want to do two things. One is I just want to say I said to Professor Johnson earlier in the day that it has been said by some that the cornerstone of a smear campaign is when you are attacked for the least plausible thing you could be attacked for. Attacking Dawn Johnson for lacking seriousness is on that list. I want to thank my distinguished colleagues for being willing to do this. There's so much we could discuss. We have 10 more minutes to schmooze down here, then we're supposed to go upstairs. But thank you all for your insight and for argument.
Thank you.